Let's call the case. People versus Sonia McLean. You got it? We clear in? Yeah, okay. All right.
Right away, this hearing already has that chaotic, something is off behind the scenes energy. The courtroom isn't even fully settled before the conversation starts circling around discovery problems, missing communication, and uncertainty about evidence. And if you watch enough courtroom proceedings, you know judges absolutely hate when basic procedural issues start slowing a case down before the real substance is even addressed. That instantly raises tension because discovery is not optional. It's one of the foundations of a fair legal process. What makes this especially interesting is that nobody even seems fully confident about whether the alleged video evidence exists at all. That's a dangerous gray area. Defense attorneys hear there might be video and immediately start thinking, if evidence exists and isn't being turned over, this can snowball into major consequences later. Meanwhile, prosecutors are stuck trying to keep the case moving while also relying on outside departments to cooperate. And Judge Simpson already sounds alert to the possibility that this could become more than just a paperwork delay. You can hear that tone developing early. This is the kind of hearing where a simple scheduling issue can suddenly evolve into a courtroom reprimand or worse. Stay locked in because this judge is clearly not interested in excuses, and somebody may end up getting called out publicly before this is over.
You said, get first from the example.
Oh, hi. Sorry. Are you working?
Yes. All right. All discovery is complete.
That's the mission. May we approach?
This is B3.
There's no need to approach, well, Mr. Brown wants to approach you kind of, but, Mr. Brown has asked me, a couple times for any videos in this case. I've sent, multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my requests for any video have gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge and get there.
He can dismiss.
Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people you requested, Mr. Brown, people have requested a YPD and they just have not.
They're ignoring you.
I'm used to that, but.
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
The response is not that there is no video, there's just no response.
Then if
I suppose if the court wishes, I could elevate my email to see if I email command staff, if they may respond, but no. It's certainly worth a shot.
This is the exact moment where frustration starts turning into judicial irritation. Notice how the courtroom conversation shifts away from technical delay and toward accountability. The prosecutor is basically saying, I've asked for the material, I'm not getting responses, and now I may need to escalate the issue higher up the chain. That is not something judges enjoy hearing during discovery discussions. And Judge Simpson immediately recognizes the bigger problem here. This is no longer just about whether a video exists. It's about whether lawful discovery requests are being ignored. Courts take that seriously, because if one side doesn't receive evidence in time, it affects fairness, preparation, and constitutional rights. What really raises eyebrows is when the judge references prior experiences with the same department. That changes the atmosphere instantly. Now it sounds less like an isolated inconvenience and more like a recurring institutional problem. And courtroom veterans know judges have long memories. Once a judge starts referencing previous discovery failures, everyone in the room starts paying closer attention.
If we want, in an effort to keep the case moving along, I understand at the end of September, and I can continue my efforts.
Well, I don't know why it's one thing if there's an issue getting discovery. This is a whole other realm. where they're not responding to a legitimate discovery request. And, you know, and I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yeah.
I don't think she does. The people around you are doing just fine. Okay. So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th. Today's the 4th. So I'm going to need it right away so that there's time. But that they're to turn over all video to the Washington County Prosecutor's Office by the 11th.
Here comes the turning point of the hearing, and Judge Simpson is no longer merely discussing the issue, he's formalizing it. That's a major escalation. The moment a judge orders a department to produce evidence under court authority, the situation changes from administrative delay to comply with the court or face consequences. And notice how direct the judge becomes. There's no ambiguity anymore. A deadline gets established, responsibilities are clarified, and the court creates a paper trail under judicial signature. That matters because if the evidence still isn't produced afterward, the court now has documented grounds to impose remedies. Depending on the situation, those remedies can range from sanctions all the way to evidentiary limitations or dismissal concerns. What's fascinating is that Judge Simpson is also trying to protect the defendant from unnecessary prejudice while keeping the case moving. That balance is difficult. Courts don't want endless delays, but they also can't ignore missing discovery. So the judge threads the needle by scheduling the preliminary examination while simultaneously ordering compliance. And honestly, this is one of those moments where courtroom authority becomes very visible. The tone changes, the pace changes, everybody in the room suddenly understands the judge is done tolerating uncertainty.
And if they then, that will go under my signature. That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, would you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter will indicate discovery is not complete, but preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on.
Just like to be able to get on the bus.
Hold on. You gotta catch me up because that was today.
No, that was the last time.
22nd.
22nd.
Mrs. Morgan, proposal.
Just hold on. Okay, you're good.
Okay.
Your Honor.
So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right?
The hearing now takes a completely different turn, and this is where courtroom management skills become just as important as legal analysis. Suddenly, the discussion shifts away from missing evidence and into a real-world conflict involving transportation, personal contact, and concerns about violating conditions. And Judge Simpson has to untangle a confusing situation in real time while making sure nobody overreacts. What stands out here is the judge's approach. Instead of immediately accusing anyone of wrongdoing, he slows everything down and reconstructs the timeline step by step. That's actually smart judicial practice. When emotions are high and multiple people are talking at once, judges often narrow the facts carefully before making any conclusions. The defendant also clearly seems anxious about being blamed for accidental contact with the alleged victim. That tension matters because in many criminal cases, even incidental encounters can create fear about bond violations or new allegations. So from her perspective, she's trying to clarify what happened before assumptions spiral out of control.
Okay. All right.
Because Ms.
Hey,
Morgan,
Bill, hold it, just hold it, just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here, asks for my advice, so.
Got it. That's it. I don't want to know what you two discuss. But out of that, there then is generated a report from Pittsfield.
Yes.
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that contact. Okay. I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that that was absolutely appropriate advice. And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one. Fair enough?
I need time to get on the bus again. Leave out the courtroom and then get.
Okay. All right. Listen, just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right?
This is actually one of the most revealing moments in the entire hearing because Judge Simpson transitions from referee to educator. He's not just ruling anymore, he's trying to guide behavior moving forward so the same issue doesn't keep repeating itself. And listen carefully to what he's emphasizing. Follow your attorney's advice. Judges say this constantly for a reason. Defense attorneys understand bond conditions, contact restrictions, reporting obligations, and risk exposure in ways defendants sometimes underestimate. The judge is practically handing out a roadmap here to avoid future problems. What also makes this moment compelling is the underlying tension between ordinary life and legal restrictions. Something as routine as taking public transportation suddenly becomes legally sensitive because the parties involved may cross paths unexpectedly. That's the kind of practical complication people outside the court system rarely think about. You can also sense Judge Simpson trying to lower the emotional temperature. He acknowledges the defendant's worry without escalating it into punishment. That balance is difficult because courts must maintain authority while also recognizing when someone is genuinely confused or anxious rather than intentionally defiant.
So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right? Okay, anything else you want to yell at me about?
I just want to have time to leave. Okay, 2 minutes now.
Not what?
I don't wanna have the same issue that happened last time I was here, Your Honor. And you asked Ms. Morgan to sit and wait for it. No.
Okay, hold on. Where is Miss Morgan here?
Yes, Your Honor.
Okay, you need to sit down. No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus have video, did nothing happen, I got off the bus.
Okay,
The bus has video, she's lying.
And I'm gonna presume you both take the same bus.
I don't have a
Okay.
choice.
I wish you would stop yelling up here at me. Mr. Feaster? I'm not gonna ask you to drive anybody, so don't tell me. Yeah, I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus. Well, no, I don't, wow.
This is the exact kind of unexpected courtroom moment that keeps viewers glued to proceedings online. Out of nowhere, Judge Simpson pivots into a surprisingly personal and humorous discussion about public buses, and the entire atmosphere loosens for a second. But don't mistake the humor for irrelevance. The judge is actually solving a practical conflict management problem in real time. Instead of issuing dramatic warnings or escalating tensions unnecessarily, he's trying to create physical separation between the parties to avoid future accusations, misunderstandings, or emotional confrontations. That's preventative judging. And honestly, the self-deprecating "I haven't taken a bus" moment changes the energy of the room instantly. You can hear the tension soften. Even in serious proceedings, judges sometimes use humor strategically to regain control without sounding overly aggressive. It humanizes the courtroom while still reinforcing authority. At the same time, the judge remains very clear about expectations. He does not want both individuals ending up on the same bus again because he already sees how quickly another complaint could land everybody back before the court. So, underneath the jokes is a very serious warning. Avoid contact, avoid drama, and avoid creating new issues.
Wow, but I just haven't. And so I know that when I get on a bus, or when I did, but is so long, the dinosaur was pulling it. But anyway, it just took me downtown, and then I had to find another bus. And I just told myself I'm not doing all that. So that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus? Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I told him his name.
Change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like I said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus. showing.
By the end of this hearing, Judge Simpson has essentially done 3 jobs at once: managed a discovery dispute, prevented a minor conflict from escalating into a bond issue, and restored order to a courtroom that repeatedly drifted toward confusion and emotional overlap. And honestly, that balancing act is harder than most people realize. The biggest legal takeaway here is still the discovery issue. The court made it crystal clear that evidence requests cannot simply disappear into silence. Once judicial orders enter the picture, accountability becomes very real. Judge Simpson's ruling established deadlines, created enforceable obligations, and protected the integrity of the preliminary examination process moving forward. But the second layer of this hearing was all about practical courtroom management. The bus situation may sound small on paper, yet these kinds of repeated encounters can create enormous complications if judges don't intervene early. Instead of reacting emotionally, Judge Simpson focused on preventing future conflict while still keeping both parties informed about expectations. And that combination firm authority mixed with practical realism is why hearings like this become so fascinating to watch online. You're seeing law, personality, procedure, and human behavior collide, live in real time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.